a suit and tie and get your hair cut way up high. Get yourself a lawyer, son. You're gonna need a real good one.
He's back in black. David Whiting, Melbourne solicitor, to answer your calls and to dispense free legal advice on this number, 1300 222 774. David, good morning.
Good morning.
Now, I was rather worried when we sent you away with homework, which was to do with Stella, who had a problem with Facebook closing down her account following a hack, a scam, and wouldn't open it back up again because I thought, oh dear, how's David Whiting going to go versus Facebook? How did you go?
I failed. I failed. I spent a day over the week trying to work out what the process was and how one might achieve nirvana, if you like, getting back on Facebook.
A whole day?
That's
a lot of money. Okay.
Over the week. Most of it on the weekend.
And?
So generally, no, I just admit defeat. I have absolutely no idea how you can run the path with any certainty at all.
Gee.
So, all right, okay.
That basically means that Stella, I suppose, will have to start up a brand new account and open a new Facebook page that doesn't have that history.
I think that would have to be the way you go,
Yeah.
and then. But it's interesting, isn't it, when you get a commercial organisation which has such an extraordinary monopoly, and to all intents and purposes is not government regulated.
Absolutely, but also where you can never get hold of a real person. Was that your problem too? That you couldn't actually speak to
Yes.
someone about it?
Yeah, yep.
Yeah.
There are people who will help you through the process,
Yeah.
or say they will for a fee. But I would have thought it would be in Facebook's best interest to, in fact, have that process, even if there was a queue.
Yeah, absolutely. Okay, well, ripper. I also received a call just before the news about a man who was very worried about carers, full-time carers for people they love, who don't have medical power of attorney at the moment, and the dreadful position they would find themselves in with getting decisions made. Any advice you can give there? But I've got lots of people on text saying, look, nonetheless, they still have power and they have authority if the primary carer has, for example, an advanced care plan in place. Then you can get respite, for example. But are you at a distinct disadvantage right now if you don't have that medical power of attorney?
Well, it's now called the appointment of a medical treatment decision maker. We've changed the terminology.
Okay.
Same process, a much better document than the old one. If you've got an advanced care directive, then the decisions of the decision maker are much less important, because you've actually set out what you want to happen, and that will be given effect to by healthcare professionals. But you're significantly better off, I think, if there is someone that you trust and who you've given the decision-making power to, and you can give them guidelines. If you've got an advanced care directive, then they're bound to give effect to your directions.
And if you wanted to get one done at this time of COVID-19, is that every bit as complicated as it always was?
I actually think they've made it slightly more complicated.
Okay.
There's a form you can download from the Office of the Public Advocate, so publicadvocate.vic.gov.au. There's a form you can download there. The difficulty is that one of the witnesses needs to be a person who can witness an affidavit in Victoria, and that's not. It's not nearly as long as a list as people who can do a statutory declaration.
Okay.
So you could go into the post office and somebody there could witness your declaration. As a general proposition, they can't witness an affidavit.
All right.
So you would probably ring around a law firm and see if you can find somebody.
We're
If
taking
you
your
can download
calls
the form.
and giving out some advice, 1300 222 774. And Pam is first up from East Melbourne. How can we help, Pam?
Oh, okay. Hi, David. Yes, my son and daughter were left. My ex-husband died back in May 19, and they were the beneficiaries of the will. But there has been a person contesting, and apparently she claims to be a partner and living with him since August 2017, and we don't know, and nobody has. Somebody has seen her on the property visiting neighbours across the road, but we just want to know whether she's eligible to contest this will.
If they were together even for 10 minutes, then she's eligible. If she's a partner, we have, you have to look at different bits of legislation. If they were in a de facto relationship and together for more than 2 years or had a child, then that person would qualify as a domestic partner.
Oh, that's what she's saying. She's a domestic partner.
There's
and
no
if she had been-
children? That she's
No.
saying? No, okay.
No. The question is that you need to put some effort into working out whether or not she was or was not a domestic partner. So it's looking at your ex-husband's network to find out what evidence either party is able to provide about where she fitted or didn't fit. Did she live somewhere else? Did she have
Yes,
another
she did.
property?
Yes, she did.
Although there are cases that talk about it's possible for a relationship to have multiple properties.
Really?
So, you don't necessarily need to live together to be in a you don't need to live together full time to be in a domestic relationship.
Pam,
Really?
what's she asking for?
Yeah, well, that's what she's asking for, 100,000, and her lawyer's fees to be paid. And yeah, she's saying that she did live with him for domestic duties.
Domestic duties in a domestic relationship are not.
You're
quite
a
the
domestic
same,
relationship. Yeah, that's what I mean. Yeah.
I mean, I think you really need to put some thought into how do I prove that she wasn't. So to me, it's things like, did she make a will in his favour? Had she nominated him as a beneficiary under her superannuation? Are there pictures of them together? Did they socialise? Are there, what's there that would indicate that they were in that relationship?
Pam, do you believe that she was in a relationship with your ex-husband?
No, she was a neighbour of his many, many years ago, and he's contacted her because my husband, in the end, was a very sick man and he died of a heart attack. My ex-husband, and the neighbours and friends around that visited Michael quite regularly, or my husband quite regularly, my ex-husband, say that they've seen her on the property but never actually living there. So,
and who goes to the house and can say what the living arrangements were in the house? Do his doctor's records show that she was the next of kin? Hospital admissions, was she noted as the next of
my
kin?
daughter was the next. My daughter and son were the next of kin, and when he died, the police notified my daughter.
Well, it sounds like you've got some detective work to do. So
Yeah, I know.
good luck, Pam.
Yeah. Good luck.
Okay.
Oh, yeah. Okay. Thank you very much.
Okay. Thank you. Michael's called in from Maryborough. Hi, Michael.
Hi, Virginia and David. A couple of years ago, we purchased a townhouse off the plan, one of 8, and before it settled, we were transferred overseas for work. We've only just returned and saw the house for the first time last week after the tenant moved out, and noticed that the landscaping that was meant to be done by the developer on the common areas along the driveway and at the front of each of the 8 units hadn't been done. Now, we have settled on it in October. Do we have any recourse to have him do the landscaping works?
What does the contract say? Does the
I
contract
had a look
say
at the
it will be
contract.
done?
Yep. I looked through the contract. I couldn't see anything that gives him an out for deciding not to do the landscaping, but I'm still waiting for the architect to get back to me.
Is he compelled under the contract to do the landscaping?
I couldn't see any clauses that says he is compelled to do it, no.
So what we're stuck with is that there was a pre-sale representation made. You might look to see if there was a planning permit that required the landscaping to be done.
I did ask the council and they said that it would be on the building permit, not the planning permit.
Okay, all right. Then the next issue is that because you bought from a developer, you have some rights under the Australian consumer law. So you do have an enforceable right. If you bought from, if I had owned that townhouse and sold it to you, you wouldn't have a claim against me because I wouldn't be covered by the Australian consumer law in those circumstances. But you bought from a person who was in the business of developing and selling. So yes, you will have a claim against the developer. So go back to him.
Go back to the developer.
Yep.
Go
Good
back
luck.
to the developer and say you've got Australian consumer law rights.
Even though we've settled on it.
even though you've settled, and what you're now doing is you're not, the issue is not the quality of the unit, which is the only thing that the contract will have talked about. What you're doing is you're complaining about the pre-sale representations made by the agent on his behalf.
Fantastic.
Good luck.
Thank you very much.
Thanks for calling in. Paul's in Altona. What's happening, Paul?
Just following on to that representation, if you take out insurance on your children, their lives, let's say A and B,
Yes.
one of them dies, you've owned the policy, you've paid all the benefits, you've made the payments.
You paid all the premiums, yes.
And when it's paid out, they pay the other one, the other child. They don't pay you. The representation that you'd made to the broker was that you were the owner of the policy and everything else. But when it comes to payout, they say, oh no.
Well, that's an interesting question though, Paul. I don't know what the contract of insurance actually says, but it is possible to have a beneficiary who's different from the person who makes the payment.
But if you had gone to the broker and said, this is how I want it to be.
Well, then you've got an action against the broker for
Right.
failing to write the policy the way you got it. But presumably you at least looked at the policy to see more than simply the life assured.
We told him what we wanted, and he said, I'm delivering you what you asked to get.
Do you have any of that in writing?
Policy was taken out 20 years ago.
Well, there becomes the problem. It may well be that the broker has since died.
No,
And it may also be, all right.
the broker's still there.
But that's your starting point. You've come along and you've bought a policy. And how old were your children at the time?
Teenagers.
Do you have an insurable interest in? Oh, you must have, otherwise they wouldn't have let you take the policy. But and so yes, you need to work out. Your difficulty will be proving what you asked for.
So are you able to do that, to go back and make the case then, Jonathan? Sorry, Paul?
Because the broker's unlikely to have a file. You're unlikely to have a file. You've just got the monthly payments to the insurance company.
Paul, is it a problem that your other son received the money?
No, it's not. But I'm just wondering, if the insurance company paid out incorrectly to what the original plan was, do I have an action against the broker or what?
Well, the insurance company will have paid out on what the policy was written as. So if the policy was written as the other child is the beneficiary, then the insurance company's met its obligations and your claim would be against the person who did the arranging.
Okay, well, Paul...
If the broker was an employee of the insurance company or an agent for the insurer, you may have something there, but you've got to go back and work out what the original deal actually was, not just what you thought it was.
So that'll have to be looking at the original document. All the best with that one. Julia in Ascot Vale, hello.
Good morning, David and Virginia. Thank you for taking my call. David, my question relates to the ownership of a mobile phone that I use for the company I have worked for. But the phone contract is actually in my name and has always been in my name. So when I started with the company in July 2018, I was required by my employer to take out a 2-year contract, a phone contract, with a telco, and that was placed in my name, not the company name. I was a full-time employee with a contract stating that I would be supplied with a company mobile phone. But what actually happened was I was instructed to go to a telco and enter and sign a 2-year contract for a phone and the service in my name, not the company's name. The monthly costs were reimbursed by the company, and at no time, despite my requests, was the contract taken over by my employer. I have now been made redundant, and my employment ceases July 28th. The phone contract ends July 22nd of this year. The Telcom has informed me that on on July 23rd, the contract ceases and the phone belongs to me. Despite this, my manager is insisting the phone belongs to the company and is the property of the company. What does the law say, David?
I think the phone belongs to you. Sorry, was this one of those really quaint old contracts where you got the phone for nothing, or did you pay for the phone as well?
Yeah, no, the phone came with the 2-year contract, yeah.
And they will have paid for the phone in full at the end of the contract?
That's right.
I tend to think the phone's, well, I don't know. It's not much value in a second-hand phone. I would not have thought. I wouldn't do anything. I would simply, Julia, I would stick with the phone and pretend it and behave that it's yours. My view is you contracted to buy it, and what I would be suggesting to your employer is that they had the opportunity of taking on the risk that your employment would have ceased. So they could have kept the phone and the number. They chose not to. So
right.
Keep the phone, Julia.
Keep the phone and keep the SIM and the phone number.
Yes.
Okay. Thank you very much, David.
Okay.
And see if they push back hard against that. Barry in Fentree Gully, hello to you.
Yes, good day. How are you going?
Good, thanks.
I was just inquiring. We went through a problem with a sole trader. We had a bathroom renovation started, which he didn't actually, it did 1 day work and then disappeared with $6,000. And we went to the DVR, and they've done all their research, and they've actually had no joy whatsoever getting in touch with him. And they've got back to us and said that, they've sent us a certificate to say that we can now go to VCAT to try and recover these things. But they just said, our agent who we're talking to at DBV said that might pay to get some other legal advice before you go to VCAT, because it might be just chasing a red herring, because they can't, he wouldn't respond to any of their reaching out to him to come and talk about the situation. I'm just wondering what your thoughts might be on spending
Barry,
more money to go to VCAT.
Do you see him around town?
No.
Does he have premises?
No, he had an address and an ABN number which had since expired recently, and the address is not where he lives at the moment. So we've got no way of tracing. We've got his registration number from his vehicle, but that's the only thing we've got to try and find out where he is.
Vic Roads won't give you that information based on the registration.
Yeah, I know that.
You're between a rock and a hard place, Barry. There was a time that if you had a registered business name, then your personal details were kept on a database by Consumer Affairs Victoria. When they moved the control of business names to ASIC, the ASIC register is now such that you can't search the address of the owner of a business name.
Yeah, that's what was. That's the trouble. If we go to VCAT, we're probably again.
Well, let's say you go to VCAT.
Have they got any powers to find him?
They won't find him. It's up to you to do the finding.
Right. Okay.
So you might find him for the purpose of serving him with a VCAT application, and you would then have a hearing at VCAT, and that'll cost you some money, and then you'll get a judgment, and you then won't be able to find him again. So there's nowhere. So I would be putting the next 6 months into trying to work out where he is and what he's doing.
Right.
So because otherwise, let's say we get a judgment against him at VCAT, you then need to get the sheriff to go and seize some goods. Well, if you can't tell the sheriff what address to go to, or you know what his bank account is, or any of those things, then you've got no ability to get anybody to attach anything.
Yeah, we have all these bank details which were relevant, because that's where we put the money through his. That's why everything was gone through his bank account to. Well, as far as payments go.
But you don't know if there's any money in it anymore.
No.
No. So your problem is find him, get an address for him,
it's detective work
and then do the
everywhere
VCAT
today for everyone.
Yes.
Thanks for calling in. Good to hear from you. Lots of comments coming in about our phone query earlier, David, and some saying port the number, meaning port it to yourself, and then give them the phone back. And then also this question: who claimed the tax on the phone? So who claimed it as a tax deduction?
The employer would have claimed it as a tax deduction.
So therefore the phone is theirs.
Well, except she was clearly they paid for the phone, but they had a contractual obligation under which they promised to give her a phone and a phone number. They did not give her a phone and a phone number. She was obliged to take the contract in her own name.
Yep.
So, and they've claimed a tax deduction for the phone.
So they're well ahead.
There's an argument both ways.
Sure.
I'd rather be the person in possession of the phone.
Let's see if we can very quickly fit in Patrick in Reservoir, because this is a particular timely dilemma he has. Hi, Patrick.
G'day. So I'm in a 4-year long-term, long-distance relationship, and the person's in Germany, and so it's very difficult to declare ourselves the de facto because we haven't lived together. But I was just wondering if there was a way to do that so we could apply for a travel exemption so we could see each other.
I'm going to take that one on notice, Patrick. I think it's an interesting question, and the question will be whether or not we could register a relationship somewhere in a period when you haven't had cohabitation. So that's going to be an interesting question for whether someone in Germany and someone in Melbourne can be in a committed domestic relationship without ever having been domestic. All right?
Yeah. Well, yeah, they're in a committed domestic relationship on social media and on the phone. And that is our location now, isn't it, Patrick?
Yeah, exactly. Well, we talk every day on FaceTime. So.
Okay.
That's where it is. But if you are going to register them somewhere, David, could you make it the Bahamas? Because that sounds a bit more interesting.
All right, I'll see what I can do.
Patrick, I'm sorry to make you wait another week. How are you both going? You all right?
We're very patient.
David will get an answer for you, so tune in next week. David, always great to have you on board. Thanks so much.
Thanks.
David Whiting there, well-known Melbourne solicitor who goes away with relationship problem-solving homework for next week. Cannot wait to see how he goes with that one after failing at the hurdle there with Facebook. Lots of people saying a life off Facebook is a happy life. Yeah, look, I agree. I have very little to do with it. But our original caller, Stella, her business is on Facebook, so it's a tricky one for her.